Right now, we are joined by defense attorney Barry Covert. Barry, thank you so much for joining us.
Thank you.
So this has been all moving relatively quickly. Why don't you break down what happened today and what kind of led up to today?
Because there was a felony hearing set for today, which a defendant is entitled to if they're not indicted and they're held in jail for 5 days, 6 days if it's over the weekend, the district attorney decided that rather than running that felony hearing, they were going to indict the case. That means that they don't have to run the felony hearing. They reported to the court that they have indicted the case, that the grand jury has voted on it, but it has not been reported out, which is technically the next stage. But they've indicated that the grand jury has voted the indictment, and so they've asked that the court move this to a status date on June 6th or June 9th. We can expect, though, that between now and then, they will issue or report the grand jury indictment. The case will then get transferred from city court, Judge Hanna, to a county or Supreme Court, and he will be arraigned on that indictment. We expect felonies for the homicides. We expect felonies for the assaults. The case will then proceed down the normal course of receiving discovery by the defense, filing motions. It'll be a long process, but it will begin the normal process after that.
And just to be clear on the indictment, when a grand jury is impaneled, they hear several cases, right? And then they issue their reports on each case, their decision, if you will, if they believe there's enough evidence. So what we are waiting for here, and why, if you read the statement from John Flynn today, saying that the grand jury has voted on the indictment, we're literally waiting for the paperwork from this panel session, right?
This panel session to then go to a judge, a county court judge, usually, who will then report out the indictment. Then it becomes public and unsealed.
Yeah.
Then they'll immediately bring the defendant in, have him arraigned on that. He'll plead not guilty to all the charges. We expect many counts here. And then the normal process will begin on exchanging discovery, filing motions. But being that this is such a complicated case with so many defendants, you can expect that that process will take a long time.
Yeah.
Now, can you differentiate kind of here the difference between the state charges we could see and possibly the federal charges we could see?
There's a huge difference between the two, because right now New York State does not have a death penalty. We can expect that the federal indictment will have what's called death-eligible charges, which doesn't mean that they're going to seek the death penalty, but for those charges, they could seek the death penalty. Then, unless they announce immediately that they're not going to seek the death penalty, there's a process that's laid out in the Department of Justice regulations whereby they then decide whether they're going to seek or certify for the death penalty. It's a long process. The defense does have the right to participate in that process. They have the right to present what's called a mitigation package, to meet with Department of Justice officials in D.C. It's a very long, drawn-out process, purposely so, because we're deciding whether a defendant is going to face the death penalty.
Right.
And we have not seen that yet in the Biden administration, where they have certified it for a death penalty. Biden is generally against the death penalty. But we could expect in this case he's going to have massive pressure to seek the death penalty, because if you're not going to seek it in this case, what case are you going to seek it in?
That's exactly right. And is it effectively a moratorium from the Biden administration? Because we have not seen that. And it hasn't been declared such. It wasn't like the president was standing up at a podium and declaring a moratorium on all death penalties to be executed in this country. But it has not been the practice. You talked about the lengthy process that will play out in the federal court system, plus appeals and everything else. We're talking about probably beyond a decade. The Biden administration will no longer be in power in this country by the time that happens. So what is preventing Merrick Garland from including the death penalty in this case, as it does qualify, and just assuming that by the time it gets to that point, there will no longer be this national moratorium?
That could very well happen. Yeah. We're trying to speculate, but you would expect that death penalty eligible statutes will be presented in the federal grand jury. If another administration in 2 years, if it's a Biden administration, then you can expect they'll follow whatever policy they have, which may well be that they seek the death penalty in this case, or that they don't. But they can also decertify it or say, we're not going to seek the death penalty. And if another administration comes in 2 years, that administration can say, we're reopening this. We want to seek the death penalty if the charges have not been resolved by then. And there could be strategy there to try to resolve the charges before that can possibly happen.
Okay. Barry Covert, defense attorney and legal analyst, thank you so much for being here. We do know that Al Sharpton, the Reverend Al Sharpton, is standing by now at Antioch Church. He is standing with other religious leaders and members of the family of the victims. Let's listen in to see if they're saying good.